Hello everybody and welcome to this episode of Activist Lawyer. We are joined today by Mary Kitson from the Equality Commission NI. Hi Mary.
Hello Sarah, it's lovely to be here.
Thanks for coming. You didn't have too far to come today, did you?
No, being a local Newry person, it was very handy indeed.
That's great. Well, we've been looking forward to having you come on for some time now, so it's fantastic to have you in the studio. There's lots that we could cover, but just with our limited recordings today, we have a few topics to touch on, but just so that everybody's familiar, Mary Kitson is employed by the Equality Commission for Northern Ireland as a senior legal officer. Mary qualified as a solicitor in 1992 and after 1 year working in a commercial law firm, joined the Fair Employment Commission in 1993. Mary commenced employment with the Equality Commission in 1999. Her role involved providing advice and assistance to people who believe that they have been subjected to unlawful discrimination and to help the Commission choose appropriate cases to support. So welcome again.
Thank you, Sarah.
So on that, Mary, I mean, you work very prominently in the area of equality and discrimination. What led you to that after, I suppose, having worked in a commercial firm? How did you get to where you are now?
Well, I think anyone born in Northern Ireland during the Troubles really has a commitment and understanding to equality and to human rights. And very much when I studied law, that's what brought me to study law, was the sense of the importance of justice and access to justice for everyone in Northern Ireland. So it was very important for me to practice in an area of law that meant something to me personally. And the Fair Employment Commission in 1993 solely dealt with the issue of religious and political discrimination in Northern Ireland. And it was a wonderful time to join that organisation. It had a very, very strong commitment to enforcement of the legislation, a very strong legal department that took cases, that established the law and very much gave teeth to the equality legislation in relation to religious and political discrimination. So I look back at that time in the Fair Employment Commission as really being a very exciting and dynamic time and a great time to be an equality lawyer. And I joined that organisation. I had only qualified for a year, but I worked with some fantastic people who taught me what equality law could do, the changes that it could deliver, and also the idea that the law in itself can't deliver change, that you need to work in partnership with local communities, with voluntary and community sector to find out what's happening on the ground, to get those cases to you, to make sure that the people who suffer disadvantage actually know about you, know how to come to you and can access your services. And then when you achieve an outcome in a legal case, that there is follow-up action, that there's work done with employers or service providers to make sure that the lessons learnt from that case actually result in a change in practice by employers and service providers. So very much that law is only part of a jigsaw that can change society. It's an important part of that jigsaw, but it must work in collaboration with other areas. And I feel that's what I learnt most about working in the Fair Employment Commission, the importance of using all aspects of our resources to make sure that change happened.
Fantastic. So you've witnessed and been a part of huge change, I'd say, around the particular areas of your work. And just the Commission itself and your role now, I mean, how can someone access support there, and how does the Commission continue to support this work in achieving equality in the workplace, for example, but in society in general?
Anyone can contact the Commission, any individual person who feels that they have suffered discrimination. They can either pick up the phone, email us, write a letter into us, whatever way they're most comfortable in talking to us and tell us their story. If someone feels that they don't want to do that themselves, that they want a family member or a member of the voluntary and community sector or some sort of advisor, solicitor, anyone at all, trade union official, representative, they can get them to contact the Commission on their behalf. So we're there to listen to anyone who feels that they may have suffered discrimination and they want to have a chat with us and to see what their rights are, what the circumstances were and how they can apply it. Sometimes people think that once you contact the Commission that you're on this roller coaster of litigation and of taking a case, and very much we say to people, you come to us, you tell us your story and we can give you advice, but you always remain in control of your own case. And if you say, I'm happy with that advice, I don't want to take any action, or I'm prepared to do some things myself to raise the issue with my employer or with the service provider, we're happy for you to do that. Or if you say, I wish to take a case and I wish to further this issue with the Commission, you can apply for help with the from the Commission to help you to raise the issue and to bring a case. So very much would stress it is in the power of the individual person to decide what they want to do, and coming to the Commission doesn't mean that you're on a road of taking a case and the Commission takes over and you lose control. I think it's really important that we are very much led by the wishes of the individual person.
Excellent. So it's not a daunting experience for somebody just to simply reach out for that help. And do matters that you take on have to be of public interest or public importance, or as you said, is it really led by the individual, in the sense that if it is an issue of, let's say, sexual harassment, I mean, and that person wants to take that case forward, is there any other way that you choose, or does anything else inform your decision to take that case, or is it?
Well, we have a policy, an enforcement policy, or a policy for the provision of advice and assistance, and it sets out the criteria with which we look at all of our applications for assistance. And unfortunately, like all public funded services, we have a limited budget, so we have to choose carefully which cases we support. So how we do that is we look at cases and to see what strategic potential they have. And what that means is what change can be effected through support of that case. How can it raise awareness about the protections of the legislation? How can it change discriminatory practices? How can it offer follow-up by the Commission? Sometimes people think that the Commission will only support cases where there is legal uncertainty or a new area of law, and that's not the case. We're there to support strategic litigation, and that is about effecting change and making people aware of their rights. So, for example, you had mentioned sexual harassment. The protection against sexual harassment has been around for many, many years, but unfortunately it's still the second highest area of sex discrimination calls that come to the Commission. So it's still very important for the Commission to take those cases, to support those cases, and make sure that people realise that sexual harassment is unlawful, that women in particular do not have to accept that in the workplace, and that they can take action, and that strong enforcement action can be taken against employers who fail to protect their staff from sexual harassment.
That's great to know. And also then, apart from the legal work and the legal support that the Commission provides, I know that you do extensive work around training as well, and have, a whole bank of resources there too. So can employers and business owners, or do they frequently contact you for support, when they feel that they want to maybe improve relations in their workplace, ensure that they're operating under correct procedures and their standards are being met? How do you manage that work or balance that work with the legal support?
The legal department in the Commission is actually one of the smallest departments, so the largest resources in the Commission are used to support employers and service providers, and we provide model policies for all aspects of equality law, and we deliver training, and increasingly as a result of COVID, a lot of that training is online delivery, webinars that employers and service providers can access totally free of charge and can see the guidance that the Commission is offering. We also have a helpline service to employers and service providers. They can ring the Commission or email the Commission or write to the Commission and to seek advice and guidance about how they deliver equality in Northern Ireland. It is important to note that the legislation only gives the Commission power to assist individuals to bring cases to the courts and to the tribunal. The legislation does not give the Commission power to assist employers or service providers to defend cases brought against them. Sometimes people will say, well, why don't you help the employer in defending a case? And what we say is, our powers come from the legislation, and this legislation does not allow us to do that. We can only assist individuals who have experienced discrimination.
Fair enough. And in terms of discrimination, are there any areas of work that you notice are more prevalent than others? I know that you would assist support around disability, harassment. What do you see as something that's really prevalent at the moment in Northern Ireland?
The most prevalent area of discrimination is disability discrimination.
Okay.
It is really by far the largest area of complaint to our services, followed closely by sexual discrimination, and then towards the bottom of the areas would be sexual orientation discrimination and age discrimination, but certainly the major area is disability discrimination, and it's both in employment and in the provision of goods, facilities and services. And that has been a consistent theme for the past number of years, and not just as a result of COVID. We've certainly seen that disability is the strongest area of complaint.
What type of matters, just in general, would that would arise from that, Mary?
We have, in disability discrimination, it's both accessing services, so members of the public, for example, who cannot access services due to perhaps access issues or policies and procedures of service providers that prevent them from attending the services that they provide. In employment, the most prevalent area of complaint is actually from people who are in employment. We get very few cases actually from people who with disabilities who are seeking into employment and who get rejected in their application. What we see mostly coming to us is people that are in employment and are experiencing discrimination in employment, in terms particularly of the management of their conditions, their illnesses, the support that they need from their employers. And it can be a bit of a vicious circle that if employers fail to make reasonable adjustments in the working conditions to support the individual with a disability, then often that person can be off on sick leave. Then they can be disciplined for their sick leave or be made redundant because of their sick leave, and it becomes a vicious circle. And I often think that if at the beginning, when there were issues in relation to disability were raised, that if an employer and an employee sat down and said, look, what are your needs? What can we do to support you? What resources are available? Look to the individual who could maybe help them with their needs, perhaps contacting government organisations or disability-related advisory services, and find out what can be done, what support is available. And if that was done, that very often a lot of the problems really would be avoided, and then you wouldn't be in the situation of a person being off on long-term sick leave, an employer having difficulty managing that sick leave and really feeling that they're left in a very difficult situation. So for me, it would be at the very point of when a person has a disability, of talking, having the confidence to know that they can raise that disability and know that they will be supported. And I think especially in relation to the stigma attached to mental health disabilities and people feeling that they can't raise it, or that they will be thought of as a lesser employee if they do so. So it's very important that you create the right culture, that people can come forward and say, I have this disability, these are my needs, what can we do to help?
Yeah, and as you say, something as simple as putting that in place at the outset and making people feel that they know that they have that support there and they're not afraid to kind of avoid, this level of action, or, even people coming to you for that type of advice. Jack, you've been looking yourself at
the
some
work with the LGBTQ community. So I know yourself, Mary, and the Commission have worked closely with the LGBTQ community. And I know previously there at the start of the podcast you were talking about working as a collective with other organisations. So what work has the Commission done with the LGBTQ community, and is it important that you work with other organisations or representatives of that community?
It's very important that the Commission works with other representatives from any community, particularly LGBTQ, because we have such low numbers in terms of people coming forward with inquiries, and really for us to understand what's happening on the ground. And therefore, if you have organisations like Rainbow, or you have solicitors who perhaps deal with a lot of issues in that area, who know about the Commission and who know that they can come forward to the Commission. And I think particularly of Phoenix Law and Kieran Moyna, who works in Phoenix Law, and the close relationship in terms of being able to discuss any problems that arise and to be able to feel that the Commission is there as a source of support and guidance. So very much important to develop that partnership work. And for example, we didn't have the Pride Parade last year or in 2020, but I remember the year before.
That's right.
In the Pride Parade in Belfast, there are lawyers for Pride, and I was really delighted to walk with those lawyers at that parade and to carry a sign that said, "I am your ally," and that sense of that you're there to support people and to listen to people. And obviously the case of Gareth Lee against Ashers Bakers, that produced a lot of awareness and interest in the issue of sexual orientation rights in Northern Ireland.
Great. And I know as well, obviously it's not just legal services, educational services as well that you provide. And I know that issues with LGBTQ just doesn't happen in the workplace, it also happens in schools. So do you provide any services for educational purposes for younger people?
Yes, we have now an education policy person within the Commission, and we'll work closely at reviewing all education policies and procedures to give guidance to the Education Authority in relation to what should be happening. We also are there to support schools, individual schools, if they have any individual queries, and we work closely with the Children's Law Centre and also with the Children's Commissioner in Northern Ireland. So if there's any issues that we can help and support on, to be working closely and to be aware of what's happening on the ground.
That's great.
And Mary, how has the Commission's work kind of evolved in these turbulent times that we lived in? Not just about COVID and the pandemic, and I'm sure you're going to deal with various issues arising from that within the workplace. We spoke briefly beforehand about maybe mental health issues arising, return to work, all of that. But also in terms of workers' rights around Brexit, perhaps, and how has that changed, or is there any way that the Commission is moving to kind of keep an eye out for issues coming up around possible breaches?
The Brexit issue is really important for the Commission, the Equality Commission and the Northern Ireland Human Rights Commission and the Irish Equality and Human Rights Commission. All of those organisations have a specific mandate to make sure that there's a non-diminution in rights as a result of Brexit. Okay. So, for example, each of the commissions in Northern Ireland, the Human Rights Commission and the Equality Commission, we have set up a dedicated mechanism within each commission that is specifically tasked to look at Brexit issues and the non-diminution of rights. And we have dedicated people who are there specifically for that work. So it's really important that we keep an eye and monitor closely. And there have been publications recently, for example, about what does it mean, and giving some sort of examples of issues that may arise, whether it be in relation to guide dogs passing through the border, or if there are issues in relation to frontier workers, or issues in relation to the employment rights of civil servants in Northern Ireland and the recruitment practices in relation to nationality. So I think that's certainly an area of work that will be very closely followed by the commissions, and the very dedicated resources, and also that we're working collaboratively with the Equality Commission, or with the Irish Human Rights and Equality Commission, and also with the Human Rights Commission in Northern Ireland.
That'll be interesting to see what comes out of that piece of work. And also, so the Commission clearly supports individuals with cases, discrimination cases and matters of inequality. And these decisions will give confidence to others and will pave the way for real change as well. But some cases have also led to practical changes. And one I'm thinking about is the Natasha McNichol case against the Bank of Ireland, where the tribunal, with the support of the Equality Commission, had removed an anonymisation order, which I think prevented the naming of both the woman and her employer. That's quite significant, isn't it? And how did the Commission become involved in that? And maybe you could tell us a little bit more about that case.
Yes, so one of the joys of working in strategic litigation is you get to work with some individual people who are truly inspirational. And one of those people I certainly would identify with is Natasha McNichol. So Natasha was a young woman who worked in a bank, and she was subjected to sexual harassment in the workplace. And she was very determined that she would establish that she had been treated very badly by her employer, and that other women would know that they didn't have to put up with this treatment in the workplace, and that they could take action. So Natasha came to the Commission and she wanted to bring her case, and we supported her in taking her case to the tribunal. She appeared in the tribunal, gave evidence for several days, was cross-examined by the barrister for the bank and also for the individual man who had sexually harassed her, and they were separately legally represented. So she endured 2 sets of cross-examination, and she had a successful outcome, a finding of sexual harassment against her. But one of the disappointing outcomes was that, due to the rules of the tribunal that existed at that time, both parties, the applicant, Natasha, and also the employer and the named harasser, were all anonymised by the tribunal. And that was a result of the old rules that were in place at the time. And Natasha was very unhappy with that. She felt that her voice was being silenced, and she didn't want to be the anonymised person. She felt that she had nothing to be ashamed of, and she felt that she shouldn't be hidden away. So she challenged that ruling to the Court of Appeal, and the Northern Ireland Court of Appeal were very sympathetic to the situation that she found herself in, and referred the matter back to the Industrial Tribunal. New rules had been introduced, a reform of the rules had been introduced, and her case then was heard under the new rules in relation solely to the anonymity point. And so Natasha could have walked away when she had her finding of discrimination. She had her compensation, the money was paid, but for her, using her voice was really important. So we went back to the tribunal, and the tribunal looked at the new rules, looked at the really important fundamental principle of open access to justice, and justice being transparent, and they removed the anonymity order against the Bank of Ireland and Natasha. And she was very happy to be able then to step up and to give interviews to the media and to tell her story and to encourage other women to come forward. And I think that really is at the essence of strategic litigation.
Yes.
So you saw someone saying it's not about the money, it's not about taking the case, it's actually about establishing rights and making sure my voice is heard. And especially given the Me Too movement and the importance of all of those gagging clauses and people being silenced, and her feeling, I don't want to be silenced and I'm going to tell my story. And she was very articulate in explaining why she wanted to tell her story. And I recently ran another case in the tribunal, another young woman who had been subjected to horrific sexual harassment by her employer. And she too applied to have the anonymity order lifted, and she gave evidence to the tribunal about the sense of empowerment that it gave her to have her voice heard, to confront the man who had sexually harassed her, and to have her name used. And she wanted to tell her story, and she talked about the sense of shame that she felt as a result of what happened to her, and how she felt it was really important to overcome that sense of shame by using her voice. And hopefully she will be able to do that.
That's fantastic. So somebody makes an application, and is it about balancing the rights of both parties, or how is it more of a sense that it would be granted in those cases, or does it just depend on the actual circumstances?
This is very new legislation, so we're really wanting to see how it works. But the fundamental principle is of open access to justice, but it is of balancing the rights of all parties.
Yes.
And the tribunal will hear evidence from the individual, but also from the respondent as to why the case should remain anonymised, but with the fundamental principle of open justice being at the heart of it. So I would hope that women like Natasha and the young woman I dealt with recently, that they will be able to use their voices.
Well, she's very brave and will have made a significant impact in the lives of many women who I suppose would look at that as inspiration and want to tell their story too, or perhaps come forward with similar cases. Have you seen, so you were saying that the sexual harassment legislation has been around for a very long time, yet we still see issues like this arising. Have you seen a noticeable shift, I suppose, in change, from your inception at the beginning of your work in this area? Are you seeing more people speaking out? Do you notice a shift in that type of area of work, in sexual harassment, for example?
I would have thought at this stage that there wouldn't be so much issues about physical sexual harassment in the workplace, and also the growth of social media issues being involved in the sexual harassment, very shocking details of cases. So that to me is so disappointing, that even at this stage of the legislation that there are very, very graphic cases of sexual harassment. And I spoke earlier about the recent case I did, and I have other cases, and it happens to women across all areas of employment, from professional people in employment right through to the young woman working in a corner shop. And it happens to women at all ages of their life as well. So it's not just young women, but certainly women across all age groups. So that to me is still that there's so much work to be done. There's so much work to be done in the area, and that's why, as part of strategic litigation, to maintain the profile, to make sure we tell those stories, to make sure that people are aware that this is what happens and that you have rights, and also for employers to know that if they don't tackle this issue at the time that it happens, if they don't take steps to make sure that they provide an important culture in their organisation where harassment of any nature is seen as totally unacceptable. An employer does have a defence to any sexual harassment case to show that they took all reasonable steps to prevent the harassment. So it's really important that employers adopt policies and procedures and make those policies and procedures living documents, that people understand it, that they're trained in it, and that they can identify that that's what sexual harassment is, and it's totally unacceptable, that there's no such defence as it's only a bit of fun and it's only a bit of banter in the workplace. Actually, it causes long-term damage to individuals working in any organisation, and it can cause employers a lot of damage to their reputation, and also the loss of really talented women who could achieve a lot in that workforce. And I look at Natasha McNichol, for example, an exceptionally bright and capable young woman, and to think that the Bank of Ireland lost an employee who could have delivered so much.
Absolutely. And I like how you say that, you know, policies should be living documents, because I'm sure it's all too common that employers feel that they've, you know, the duty is, as long as you have a policy in place there, you've kind of ticked a box and that's it. But there's much more to it than that. They have to be updated, they have to be made known to all employees, and there must be proper procedures in place, and as you said, to update it, make it a living document. And I'm sure it is the case that often doesn't happen, where, you know, training isn't provided, etc., etc. So it's not enough to simply tick a box and say I have a policy in place. So
That's
really
right.
they should seek support around that, shouldn't they, too?
And it's very important that employers realise that. I recently dealt with a case of Siobhan Jacobs against the Yellow Door Portadown Limited, and it was a disability discrimination case, and Siobhan was a woman who was a senior events manager for the company, and she developed cancer. She was off work for some time, and she came back to work, and she wanted to have reasonable adjustments in the workplace. Her working day at times could have been 12 to 14 hours if she was doing events that were very long and a distance away. So she asked her employer, could I do shorter events? Could I work a sort of an 8-hour day and not have to do the longer events simply because of my disability? I'm recovering from cancer. She produced a letter from her oncologist who supported her need for reasonable adjustments in the workplace. She contacted Macmillan Cancer Support. They helped her to write a letter to seek those reasonable adjustments. And rather than give her those reasonable adjustments, Siobhan was disciplined and threatened with disciplinary action for failure to follow a reasonable work instruction, in that she was saying she couldn't work the very, very long shifts. But when I looked at that case, that employer had endless policies and procedures, had very, very detailed policies and procedures in relation to equality, and also in relation to how grievances and complaints and disciplinary action should be taken. But those policies weren't followed in the case, and the result of that was Siobhan Jacobs brought her case to the tribunal. After 4 days of evidence, the respondent, the employer, settled the case and gave Siobhan £40,000 compensation. And Siobhan Jacobs, all she wanted to do was to work shorter shifts. And to me, if a conversation had taken place at the right time to say, you're back at work, what are your needs? Have you any medical evidence that supports your needs? What can we do to help? What can and can't you do? If that conversation had taken place, plans had been set in foot, there would have been no need for a very stressful and lengthy litigation process and a hearing for 4 days. And then for Siobhan to end up losing her job, she felt she couldn't have continued, and she resigned from employment. And again, for Siobhan Jacobs, it was about making sure that other people who had cancer knew that they were protected under the disability legislation. Cancer diagnosis results in protection from day one of diagnosis, and that people like Siobhan had rights in the workplace, had a right to be treated fairly and to have their disability factored into all of the decision making about their employment. And if that had happened, the policies had been followed, Siobhan wouldn't have been forced out of her job, wouldn't have been forced into litigation, and the employer wouldn't have had to deal with a very lengthy and expensive set of litigation for all parties.
Wow. Yeah, I mean, it's good to have an insight into the lived experience and to see how, you know, an outcome like that is achieved. But you're right, very early intervention can prevent all of that.
Yeah, listening to that work, I'm inspired, and I know a lot of people that will be listening to this will be inspired to get into your area of work. So if you could give advice to young people who are starting off in law, or young people who have just qualified.
Aspiring lawyers.
Yeah, aspiring lawyers. How to get into your area of work, if you want to just give some advice to them.
I think equality in human rights law is an amazingly inspirational area of work to work in, and I feel very privileged to work in that area. What I would say to anyone who wants to follow a career in this type of work is to really connect with people who are disadvantaged. And that can be as simple as, when you're a law student, getting involved in charities that support, for example, disabled people, charities that deal with homeless people, people who have maybe immigration or asylum issues, domestic abuse issues. There are lots of ways that you can try and connect with people who suffer disadvantage. And the most important skill to me is about empathy and about really understanding where people are coming from. And if you can try and get an insight into real disadvantage and to see how it works and how you can help people to maybe raise issues, to support them, to navigate their way through systems, public systems in Northern Ireland, to make sure that they can access their rights. Now, I appreciate that when many students are full-time students but also have jobs, and it's very hard to find the time to get involved in these issues. But even if you could take 2 hours a month to help somebody to write a letter, to attend a meeting, to give advice on a telephone call, to really get to know how disadvantage works at a very fundamental level, and to how you can help people through listening to their story and seeing what rights are available, because it is difficult to understand the legislation in Northern Ireland. It's difficult to understand the case law. We're different from the rest of the United Kingdom in terms of our equality laws, and there are so many people out there with unmet need. One of the biggest difficulties is that legal aid is not available for employment tribunal work, so that if an individual doesn't have the money to pay a solicitor, if they're not a member of a trade union, if they don't have a private household insurance policy, then where do they go? They can come to the Commission. We don't have the resources to fund every case, to support every case, and people can end up feeling very isolated. And if there were ways through organisations, for example, like public interest litigation, PILS, CAJ, other charity voluntary work, and whatever area of law that you're particularly interested in, to try and find out voluntary and community sector groups that work with those people. And if you can connect with those people and try and help them to, and it can be as simple as having a conversation and taking the time, that can really give you a good basis for understanding disadvantage. I always remember one of my very first cases in the Fair Employment Commission, and it was a redundancy case. A man had been made redundant from Shorts, and he was a Protestant man, and I read all of the papers, and I could see the selection criteria for redundancy, and I could see why he had been selected for redundancy. And I met with him, and I was going through all of this paperwork, and he became very frustrated with me, and he banged the table with both his hands, and he leaned forward and he said, "You don't understand, love. I was born to work in Shorts." And I remember very clearly, I didn't understand his perception at that stage, and it really caught me in terms of, yes, I had a legal understanding of what his case was about, but until I understood his thinking and my ability to explain to him what had happened, that I really didn't have the skills to deal with that situation. So I think the more you connect with people, the more you understand disadvantage, and that's really important thing to do for any lawyer, whatever area of work that you want to fall into.
Fantastic. So Mary, just obviously the title of our podcast is Activist Lawyers, and it's fantastic that our guests, including yourself, are so passionate and committed within the areas that they work in. What advice do you have in terms of somebody who feels that they want to champion a cause, or can you use law as a tool to affect change, in your opinion, and what does activism mean to you in that sense?
Activism to me really means affecting change. There's no point in having laws that are in some dusty book somewhere that people can't use. And so it's very much about what does it mean for the individual on the street. I remember one of our former chief commissioners of the Equality Commission, Bob Collins, when he was leaving the commission, his leaving speech to the staff was always ask yourself, how relevant are you? And to me, law is only relevant when people can establish their rights, can use their rights, and that it means that they're treated fairly and with equality. And we've seen cases that deliver that change. You know, very simple cases can deliver real change for individuals. Strategic litigation can really change people's lives. And I think of a very simple example of that is a case I dealt for a young woman called Sinead, and she worked in a clothes shop, and she was a full-time worker, and she was a supervisor, but she went off on maternity leave, and when she came back to work, it was very much that she couldn't be a supervisor and work part-time. She wanted to reduce her hours because of her childcare issues. And a simple case like that changed the policy of that company. They had to accept that requiring women to work full-time to hold a supervisory role was indirectly discriminatory, and that shouldn't happen, and that policy was changed not just in the stores in Northern Ireland but throughout the UK. So those kind of cases can really change an individual's life but also benefit other people.
Fantastic. So we have examples of various cases that people can check out on the Equality Commission NI's website, but it's just been fantastic to have some insight into cases in action and to really hear how something can make real change and to see these outcomes. And Mary, thank you so much for joining us.
Thank you very much, Mary.
Thank you very much. I really enjoyed talking to you both.
Fantastic.
It's been great.
Great. Thanks, Mary.
Thank
Talk
you.
to you soon.
This podcast was recorded in Granite Podcast Studio. Interested in starting up your own podcast but don't know how? Granite Podcast Studio can help. Record your podcast in our state-of-the-art studio, which is based in the heart of Newry City. Our studio has cutting-edge and user-friendly technology and can seat up to 4 people. We also provide an editing service for our team, using your guidance and editing notes to provide you with a flawless finished product, leaving your listeners wanting more. For more information on how you can get started, visit www.granitepodcaststudio.com.